Good morning, everybody. Happy Friday the 13th. So we'll see if that makes for an interesting Friday for us or not here in the courts. Let's start out this morning in Florida. This is Wade Mercer. He is doing first appearances.
I'll set a bond of $25,000 cash or surety. That's still less than what I normally would set. I'm not going to set a $10,000 bond on first degree felony, whether the state asks for it or not, with this complaint, and she's not even here to ask for it. So that's the bond I'm setting. You've got a condition. Miss Jeffcoat's coming into the courtroom now. Ms. Jeffcoat, that bond that y'all have agreed to is about a fifth of what's normally set. Normally a $50,000 bond is what we see on trafficking. So I was trying to see if there's any additional circumstances or information I need to be aware of.
Just the age of the case, Your Honor, that it came to us late. We didn't get it until May, but
It looked like it was in DOC's control. It was outside the state attorney's office.
outside the state.
They held it almost 2 years. About a year of that looked like waiting on a lab result. I have no idea what the other year delay was, but that's unfortunately that's not unusual with Department of Corrections inspectors.
There was another inspector that was originally on the case, and when that inspector left, the inspector that filed it had just inherited it. So it is a DOC issue, but it wasn't the signing inspector's issue.
Thank you, Mr. Freeman. I've had this conversation with them before. When I get delayed warrants that don't have a good reason, Department of Corrections, it goes through so many bureaucratic levels. It's got to get approved by so-and-so. It's got to get approved by their supervisor and their supervisor and their supervisor. So it goes to about 3 levels before the prosecutor ever gets it. And if the prosecutor has a change, what an inspector has told me is if Ms. Jeffcoat has a change and says you need to add this, they got to start over. Then that new one's got to get approved by supervisor one, supervisor. It's just extremely time consuming.
Yes, sir. Yes.
So I'm going to set the bond lower than normally would, but I think a $25,000 bond is about as low as I'm willing to go with this allegation. So it's cash or surety with a condition of random urinalysis. You post the bond immediately, you'll be released immediately, Mr. Rivas. Mr. Freeman, anything else today, sir?
Just a question about the random urinalysis, Your Honor. When he does bond out, where does he need to go afterwards to check in?
It will only be upon Judge Garcia or myself if ordered it. Typically, that's just going to be for court dates. That's a condition that she asked to be placed on felony drug cases, and it's usually only court date, Mr. Freeman. But he very likely will be drug tested at a court date, so be aware of that possibility.
Yes, sir. Will do. I'll take care of it. I'll contact his family immediately. Thank you so much.
Thank you, Mr. Freeman. Wish you the best, Mr. Rivas.
Yes, sir. Maybe excuse,
Thank you,
please.
Yes, sir. Thank you.
Mm-hmm.
We do have friends or family here in one case today, so let's go to that case next, and that is Tierra Davis. I may be mispronouncing that first name. Am I saying that right? Is it Tierra? Ms. Davis, good morning. Ms. Davis, you are here, ma'am, because you've been accused of 1 count of battery. Ms. Davis, your husband, your family, you got some family here, your mother and your grandmother, all are in the courtroom, Ms. Davis. I've read the complaint. There is probable cause for the charge of battery. Ms. Davis, the criminal history I've got shows no prior criminal history, ma'am. Is that accurate?
Yes, sir.
Ms. Davis, let me see if Mr. McDaniel or Mr. Mitchell have any additional information before I address your bond status. Mr. McDaniel, anything?
Yeah, she lives locally, and I know you just said that her husband was in there, and I think he was a victim. So I know they live locally, work, and we just asked the court to consider an ROR or a cash bond. I mean, whichever the court feels most appropriate.
Mr. Mitchell.
If the court is considering a cash bond, we don't object to it.
And sir, to her husband, you're not wanting contact at this time, but possibly in the future that may or may not change. Is that right? Okay. So, Ms. Davis, what I'm going to do is I'm going to let you pick between a conditional release and a cash bond. I very rarely give an ROR if there's probable cause. I made a note. This is just the complaint. I made a note, and my note says weak case. So it may be difficult for Mr. Mitchell to prosecute the case, but there still is probable cause. That's just based on what I saw in the complaint. And Mr. Mitchell will have to make that decision. And y'all may be able to work this out with Mr. Mitchell may have, I think there's going to be a request to drop charges possibly filed. So if you want to post a cash bond, I have no problem with that. The cash bond is $250 cash. I'm going to offer you a conditional release. You will have a condition of no contact with the alleged victim for the time being. Now, based upon this complaint, if you and she both want contact at some point next week or whenever, then I'm telling you, I would authorize it if you both want it. In order to do that, you have to come to the probation office and sign a form, bring an ID with you, sign a form saying you want contact. That may not happen, but if it does, that's where we stand. Is there a child involved in this case? Okay, so the no contact has nothing to do with the child. It's only a no contact against you. As far as living situation, you were living together when she got arrested yesterday, correct? Do y'all have a plan worked out on who's going to live where? Or Ms. Davis, do you have somewhere else you could go on a temporary basis other than the home you were in?
Yes, sir.
Where would that be?
Either my grandmother's or my mom's.
Ladies, either one of those places? Okay, so you've got other place to go. So what'll happen is you go somewhere. Now, if Mr. Davis goes somewhere, you can go to the home. But as long as he's there, I can't force him to leave since he's the alleged victim. But no contact, at least for the time being. Mr. McDaniel will explain to you, and he may have already explained to you the process of getting your clothing and other things you may need out of the home. Ms. Davis, do you have any questions?
No, sir.
Let me see if the family has any questions. Does the family have any questions? It's $250 that's paid at the jail. When that $250 is paid, she's released. The good thing about a cash bond is this. If the case is dismissed, and I don't know if it will be, but if it is, a cash bond is going to be returned to whoever posted it. Okay, if it's not dismissed, if she's ordered to pay court costs and fines, the cash bond is taken and applied toward those court costs and fines. So a cash bond will be dismissed if the case is dismissed. All right, any other questions? All right, so as soon as it's paid, she'll be released. Ms. Williams. Thank you. So we're also going to give you a court date. When would that be for? I'm going to ask the jail to give you a notice for June 30th for an arraignment date at 9 a.m. That's if the case is still pending. It's going to be close. Mr. Mitchell may have time to look at it before then. I don't know. What I would suggest you do, Ms. Davis, is contact the clerk's office like the Friday before court. If they tell you the case is still pending, you've got to be in court on that day, and they'll give you a written notice at the jail before you leave for that court date. If they say the case is dismissed, you don't have to be here, but you've got to be here if the case is still pending. Any questions?
No, sir.
All right, ma'am. Wish you the best. So as soon as that's posted, ladies, she'll be released.
Did she say she was going to do the cash bond?
Yes, she said the cash bond. We have Rajon Higginbottom. So Corporal, I think I addressed this the other day at his first appearance, but it's still not been fixed. His last name is still misspelled in your system. Corporal Drowns, his last name is misspelled. It was misspelled at the previous first appearance, and I asked him about the spelling of his last name. Everything else has Higginbottom with 2 T's, except the jail document. So once again, if y'all can correct that at the jail, that your system's wrong, please. Mr. Higginbottom's last name. Mr. Higginbottom, you have in addition to your local charges that you now have a warrant out of Duval County. I have a copy of it in front of me. It's a no bond warrant where you're accused of violating the terms of your probation. So Mr. Higginbottom, just be aware of that. You have that hold now in addition to your local charges. Mr. Higginbottom, do you have any questions?
Yes, sir. I was gonna ask you guys, because of the circumstances of my charges and the circumstances of the situation, I was gonna ask for a bond reduction. But if not, I mean, I understand 100%.
Yeah, Mr. Higginbottom, given that you're on probation, the allegations against you, I set your bond at $5,000, which I think is reasonable. It's fairly typical. It's extremely typical for Jackson County for someone who's on probation. So, Mr. Higginbottom, if you are able to post a bond, you won't get out of jail. You'll go to Duval County. Be aware that if you don't post a bond, you resolve these charges here first. Wish you the best, sir. Next case is Steve Bennett. Mr. Bennett, good morning. Mr. Bennett, you're here for first appearance accused of 1 count of trafficking in fentanyl, 1 count of possession of methamphetamine, and 1 count of possession of drug paraphernalia. Mr. Bennett, there is probable cause for these 3 charges. I'm going to appoint the public defender's office to represent you. I'm going to ask that you listen to Mr. McDaniel, and then we'll listen to Mr. Mitchell, and I'll set you a bond. Mr. McDaniel, anything?
Judge, I was just, Jake may know, it was 4 grams of, fentanyl. Is that what they alleged? I mean, is that trafficking or? I didn't look at that.
The allegations are 5 grams, and I had to go look at the statute myself because we don't see that very often. And fentanyl, the cutoff is 4 grams.
Mm-hmm.
So for fentanyl, anything above 4 grams alleged is trafficking. And then the methamphetamine wasn't trafficking amount in this case. That was the other case. Anything else, Mr. McDaniel?
Just for reasonable bond, Your Honor.
Thank you, Mr. Mitchell.
Reasonable bond under those circumstances and random UAs.
Okay, so Mr. Bennett, it's a trafficking case. It's a first degree felony, but it's slightly over the amount, and it's a very small limit for fentanyl. And I understand the purpose of that. Fentanyl is an extremely addictive substance and a deadly substance. So the bond's going to be $25,000 on the fentanyl, $5,000 on the methamphetamine, and $2,500 on the paraphernalia. Your total bond, Mr. Bennett, becomes $32,500. Is that right, Dawn? $32,500 cash or surety. You do have a condition of random urinalysis, Mr. Bennett, and you'll get a chance to use the phone in just a few minutes, sir, to try to post that bond. Mr. Bennett, you and I may be the only two people in Jackson County that have ever been to Johnstown, Pennsylvania. I went there, took my son. There's a wrestling camp there called Young Guns. So I was in Johnstown, Pennsylvania last summer. I just happened to notice that original hometown. Do you have any questions, sir?
Don't say about the case.
No, I
Questions,
work.
not about the charge.
Yeah.
Don't talk about the charge, but if you have a question,
No,
I'll try to
yeah.
answer it.
Yeah, I work and I have to be, if I can get a reduced bond.
Yeah, the problem is you're charged with a first degree felony if you're convicted of this, and you haven't been. But if you are, the fentanyl charge carries a minimum mandatory term of imprisonment. That's why the bond is so high. It's a very serious charge you have on the fentanyl.
It's all right.
Have a good day,
That's
sir.
Yeah.
All right. Look,
Okay.
We have already seen Mr. Rivas. That brings us to Timothy Paramore. Actually, I can see, and Mr. Paramore's slightly different than the other cases. So let me see Mr. Paramore first. Mr. Paramore, good morning. Mr. Paramore, you're here for the charge of violation of state probation is what the jail sheet says. Now, the warrantless arrest by the probation officer says conditional release. So, Mr. Paramore, when I looked at your Department of Corrections website, I'm not real clear about it. Were you recently released from custody from DOC, or have you been out of custody for a while and on probation?
I've been on probation. I was released in 2019.
The allegations are that you failed to provide an address where you will be living. That usually when I see that, it's when someone gets out of prison and they don't have an address. So it's a little unusual to see someone who's already out on probation and arrested for this offense, but there's probable cause for it. That's what the officers accuse you of. What I'm gonna do is well, let me see if the attorneys have any additional information before I make that final decision. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell?
No, Your Honor.
So, Mr. Paramore, I'm going to hold you 10 days. That's normally what we do with VOP cases. I'm going to treat you like a regular VOP, even though it says conditional release. Are you on conditional release or are you on probation?
I was on probation, so I don't know. And they had my address, so I don't know where that's coming from. So I check in every month. I had 3 months to go.
Let me see when this is
I got
dated.
off.
It's dated
So I don't
yesterday. Okay, so what I'm going to do is this. The Department of Corrections website says the same thing you're saying. It says you're on probation. But the probation
sir.
officer has accused you of violating in terms of your conditional release. Conditional release is what they used to call parole. Conditional release means that you just got out of prison. The only way you could violate your conditional release is if you were on conditional release, first of all, and then lost your place of residence somehow and didn't have anywhere else to go. So I'm not real clear with what the accusation is. I'm going to let them know I'm going to see him Monday.
Okay.
Let the probation officer know I want to see him Monday, because if she clearly says conditional release, but he's saying he's not on conditional release, and the DOC website says he's not on conditional release. So, Mr. Paramore, I want to see you Monday, so maybe we'll get a little more information in your case. And if they can file a little more detail or give us some more information, Mr. Mitchell, to y'all, then y'all can present that. So I may not hold you the whole 10 days. I want to see what the allegations are, because there's a contradiction in the Department of Corrections website and the affidavit filed by your officer. I'll see you Monday, okay?
Yes, sir.
Have a good day.
You too.
Next case, thank you. Next case we have is Ashley Hendricks. Ms. Hendricks, good morning. Ms. Hendricks, you're here because you've been accused of one count of introduction of contraband, a third-degree felony in the Department of Corrections, and one count of unlawful use of a two-way communication device, also a third-degree felony. Ms. Hendricks, there is probable cause in the complaint, ma'am. And Ms. Hendricks, I'm going to see if the attorneys have any additional information before I address your bond status. Mr. McDaniel, anything?
Yeah, I just ask, take into consideration her criminal history and, that's all I got.
Thank you, Mr. Mitchell.
No, nothing. Your Honor.
Thank you. Ms. Hendricks, I'm going to set you the standard bond I set for this charge. You do have a great criminal history, but the charge against you is very concerning. So what I'm going to do is set your bond at $5,000 on each count. So you've got a total bond of $10,000. It's cash or surety, Ms. Hendricks. That means you do not have to come up with all the money. Ms. Hendricks, you do have a condition that you have no contact with any Department of Corrections facility and no contact with anyone in the Department of Corrections. That's a condition of your bond because of the allegations against you. You can have no contact with anyone currently in the custody of the Department of Corrections because the allegations, they've accused you of attempting to introduce contraband, but they couldn't actually prove the contraband. So the contraband in your case is the actual text messages you allegedly exchanged with an inmate. Ms. Hendricks, you'll get to use the phone in a few minutes to try to post that bond. Do you have any questions?
No, Your Honor.
Have a good day, man. Jason Porter.
So good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Friday. It is Friday the 13th, so good luck, everyone. We're not going to go there because the hearing that's going on isn't all that enticing. But real quick, I wanted to show you bottom left. It's not, but tell me that doesn't look like Senator Mitch McConnell. Just saying. Let's go back to Judge Mercer. Courts are slowly trickling in this morning. It's kind of a slow start, but we'll ride with this judge for a little while.
Were allegedly communicating with back then.
No, sir.
Okay. Mr. Mitchell, what's the state's position on her having telephonic contact only with her husband?
We have no objection.
Okay, I'm going to make an exception then for telephonic contact with your husband. Thank you for bringing that to my attention. Okay,
No problem. Thank you.
have a good day. All right, Jason. Mr. Porter. Mr. Porter, good morning. Mr. Porter, you're here because you've been accused of violating the terms of your state probation. Mr. Porter, I've got a copy of the warrant in front of me. You have a no bond warrant issued by Judge Garcia. Mr. Porter, what I'm going to do is I want to get you arraigned today because I want to get you appointed a lawyer if you're asking for one. Mr. Porter, do you want an attorney appointed to represent you in this VOP charge?
Yes, sir.
I'm going to appoint the public defender's office to represent you. Listen to Mr. McDaniel. He's going to give you some information, and then we'll see if you have any questions.
Yes, sir.
We're going to enter not guilty. Yes, to set this on July 10th pretrial docket, and I advised him, Mr. Guy Green, to come by and talk to him prior to that hearing.
And Mr. Mitchell, anything?
No, Your Honor.
Mr. Porter, July 10th, Mr. Green will see you before your court date. Any questions?
No, sir.
Have a good day, sir. Jordan Lopez. Mr. Lopez, good morning. I think our jail sheet is wrong in your case, Mr. Lopez. It says violation of state probation, but when I looked at the warrant, it actually appears to be violation of county probation. I'm going to appoint the public defender's officer to represent you in this charge. I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, Mr. Lopez is going to admit that he violated his probation, understanding he's going to be sentenced to 90 days in county jail. He have 1 day jail credit, and he remaining fine to be there. He just wants the court to be aware. I mean, he's going to admit no matter what that, he works, he has a job, he just purchased a house or something he's trying to make payments on and whatnot. And, and he just wanted the court to be aware of those things. And, but whatever the court decides is what the court decides.
Okay, thank you. And Mr. Mitchell, anything from the state?
Nothing from the state.
Mr. Lopez, the basis for that offer was that you allegedly just quit reporting last January, and that you reported for about half the time you're supposed to and quit reporting. And then also taking into account is the fact that you allegedly got arrested, or you did get arrested this week in Bay County for a battery by strangulation. So those are the factors that I have before me today, and that was the factors that went into the tentative offer that was made this morning. Mr. Lopez, is there anything else that you want me to be aware of?
I have been in contact with my daughter, and I know the last time that I saw you, that was one of the reasons why my license was suspended. I've been making the payments currently to keep up to date with that, and I've been keeping my daughter in touch with me because she's been harming herself by not being able to contact me. So I'm adhering to anything that the judge wants me to do. I'm just trying to get back home to make sure I can see my kid, take care of what I got to take care of at home.
Help me understand. I'm missing something I don't know about apparently. If you were out of custody before yesterday, why can your daughter not see you?
So basically, I'm in an agreement with my child's mother that, you know, if I keep up to date and contact with everything, because my daughter's been doing therapy for the last 6 months. She's been harming herself and it was trying to get my attention. And I had a conversation with her saying, you know, I've been trying to work to get my life in order. I was trying to catch up with all my payments during the time when I stopped paying for the things that were going on with my probation. I had an increase in the rent that I was staying at, and I was just trying to make ends meet, and that's why I didn't report it back. And then once I got back on my feet, I've been trying to handle everything to get everything according to. I didn't even know I had a warrant. If I did, I would have turned myself in, so I could have addressed it sooner.
Someone called on your behalf. Let me see who this was. They
believe it
didn't
was
call
my
until
mother.
you. Okay, so that was your mother. The person that's the alleged victim in the new charge in Bay County, the felony case that you posted bond on, is that the mother of this child we're talking about?
No, sir. That's my
That's
ex-girlfriend
someone else.
that just happened recently.
So, Mr. Mitchell, that tentative offer that the court made this morning was based upon the information that we had at that time. Is there anything that he has said that you think state would want to lower that offer?
Maybe 60 days.
I don't have a problem with that. Mr. McDaniel, you okay with that instead?
Yes, Your Honor, we're going to admit to it no matter what. So, I mean, that's
Okay.
what.
So, thank you, Mr. Lopez. I'm going to accept your admission that you violate terms and conditions of your probation in light of what you've said today. It is possible you didn't know. Now, I don't. You quit reporting, so you may not have known about the warrant, but you knew that you were on probation. Certainly appears you were sentenced to that and instructed according to what the probation office has filed. So I'm going to accept your admission that you violated the terms of your probation, revoked that probation, Mr. Porter. Mr. Lopez, I'm sorry, sentenced you to 60 days in the county jail. Give you credit for the 1 day you've already served. The remaining court costs and fines will still be owed, and those are the amount of $180. There'll be a civil judgment against you if you don't get it worked off. Maybe you'll get it worked off at the jail. There's no probation involved in this sentence. You finished that sentence, sir. This is all behind you. Any questions?
No, sir.
Wish you the best, sir.
Jake, would you mind, I don't know, maybe seeing if you can ask the prosecutor in Bay County to move that arraignment date from July 7th, maybe to August or something, you know, just to give him a month, you know, so that he can finish up this sentence. He's bonded out, but he's got an arraignment date this July 7th, and, you know, just keep some of the, you know, arrest warrants and him having to go up there and then to realize what he was in jail, then let him out.
Mr. McDaniel, I appreciate that. So Mr. Lopez, a lot of times attorney, that's not Mr. McDaniel's job. His job is to deal with this charge here, but I appreciate him taking time to try to help you out on the case in another county. So I appreciate that request, Mr. McDaniel. So maybe they can get that court date continued, and we'll see what happens. Okay.
Thank you.
And next case we have Ernest Dixon. Mr. Dixon, good morning. Mr. Dixon, you're here for first appearance accused of 1 count of trespassing and 1 count of resisting an officer without violence. Mr. Dixon, I'm going to appoint the public defender's officer to represent you in these 2 charges. I'm going to ask that you listen to Mr. McDaniel, your attorney.
John, you're muted.
Apologize. We're going to enter a plea of no contest. Understanding he's going to be sentenced to 4 months in the county jail. He'll have 1 day jail credit, be a $370 fine. He has signed his plea waiver form, waive his right to jury trial and call witnesses.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Mr. Dixon, did you hear that agreement?
Yes, sir.
Mr. Dixon, you have any questions about that agreement, sir?
No, sir.
Mr. Dixon, is that the plea that you would like to enter to resolve this case?
Yes, sir.
Mr. Dixon, I'm going to accept your plea of no contest to the charge of trespassing and resisting an officer without violence. Is it trespassing in first degree or second degree? I'm going to adjudicate you guilty of those offenses, then sentence you to 4 months in jail on each case running concurrently. They're running at the same time, so it's 1 4-month sentence. Give you credit for the day that you served in jail. I'm going to impose a standard court costs and fines in count 1, waive the court costs and fines in count 2. So it's total court costs and fines of $370. Mr. Dixon, there's no probation to follow. And Mr. Dixon, when I looked at your case from last year, that was back when the judge was involved in Public Works recommendation. So I don't think I recommended it that time because of your history. But Mr. Dixon, I'm no longer involved in that. That's entirely within the discretion of the jail. So if you want to qualify for the trustee program, talk to the jail about that. They'll explain how it works, but that may get you some extra gain time and get you out earlier. Mr. Dixon, do you have any questions?
No, sir.
All right. Wish you the best, sir. We have Colton Price.
So just an update for all of you while he's between contestants. I've been going through the various court feeds that I regularly monitor this morning, and it is a slow start out there. A lot of them are running landlord-tenant, which is not the most compelling stuff. It's an exercise in misery. But there's a couple things going on. But for the moment, I'm going to continue here in Florida, and then we'll move on in a little while. There's, again, a couple places we can go, but this is the best at the moment.
$1,000 on the paraphernalia with a condition of random error analysis. But I'm going to hold you for 10 days with no bond. I'm going to ask Mr. Mitchell to notify the probation office. He's been on probation for a while. Apparently,
Yes, sir.
successful. It's 19326 CF. So he's been on probation for 6 years, 5 years, Jackson County. So, Mr. Price, I think the probation office, I know I'm going to want one. I think the probation office would be interested in seeing your analysis. I asked the jail Corporal Drown to try to get one this morning. I think you've not been able to do that yet. You'll be given a chance to do that after first. Has he down, Corporal?
Yes, sir, he did.
And there are the results?
Yes, sir, he was positive for THC and cocaine.
Okay, Corporal Drown, if you'll send that email to Mr. McDaniel and Mr. Mitchell and myself, Mr. Mitchell will then make the probation officer aware of that also. So, Mr. Price, I expect a violation of probation warrant coming because of the new arrest, but also because of the urinalysis. But that's something they need to take into account. And I'm impressed. I don't see many people that make 4 or 5 years of probation with no violations. That's a good thing. And that actually may help you in getting this whole thing resolved. Any questions?
Yes, sir. I just got a set of twins on the way. I found out here recently. I've been working. I'm on probation. I've been very, like you said, very successful over these past 2 years. And I work, and I just want to be able to be there for my twins when they get here, sir.
What's their due date?
Matter of fact, my father's birthday is February 6th.
Well, if they send you to an inpatient drug treatment, I'm not saying they will, but if they do, you may be out by their birth if things work quickly. A lot of times when you see someone do as well as you, that may be an option. Who knows? We'll see what happens, but I'm going to see you in 10 days or before then if there's a warrant signed before then, okay?
Yes, sir. If y'all got to tighten down on my probationary or random, just whatever, I'll just do whatever. Ankle monitor. I just want to be there for my twins when they get here, Judge.
Okay. That'll come before Judge Garcia. That'll be her decision, but she'll list everything that she's presented with, okay?
Yes, sir. You have a good day,
Have
sir.
a good day. Have a good day. Stephen Griffey and Carrie Bowden. Let me see them one at a time because the complaints are slightly different.
He said he wants one at a time.
One at a time, okay. Their complaints are just a little different. Mr. McDaniel, actually, I think they're done by 2 different officers. Yeah, so Mr. Griffey, you're accused of 1 count of battery on Miss Bowden. She's accused of 1 count of battery on you. So, Mr. McDaniel, I wanted to get your and Mr. Mitchell's take on the complaint. I've read it a couple times. What's your position on probable cause, Mr. McDaniel?
I'm completely honest, it's a close call. I mean, there's not much there. I mean, obviously they're fighting, walking down the road, causing some kind of a little bit of disturbance. Whether there was actually a battery that it happened on either one of them, it's unclear. I mean,
okay. Mr. Mitchell?
Mr. McDaniel's right. It is kind of a close call, but both deputies do say the same thing due to the lack of information that was provided by both of them, which is, a primary aggressor wasn't able to be determined.
So here's a concern I have. Let me just read the complaint into the record. It says that the relevant portion of it, this is Miss Bowden, stated that she got an altercation with a boyfriend of 1 year. He chased her down, and at that time, and this is the quote, they both began to physically fight. They both began to physically fight. By the definition of battery, somebody had to commit the crime first, and the other one may have been committing a battery, may have been acting self-defense. The problem is they both began to physically fight. Can't be probable cause for both of them. I think there was an injury. It was his nose was bleeding. I just don't know that. I don't think that's enough. It's not enough for me for probable cause for battery. They both begin to fight. Somebody's got to say somebody hit them, struck them, or touched them against their will. Those are the elements of battery, and they both began to physically fight. It's not enough for battery. Mr. Griffey, do you want to have contact with Miss Bowden?
Absolutely.
Okay, just step back, Mr. Griffey. Let me see what Miss Bowden's situation is. Miss Bowden, come on up. Miss Bowden, I've read the complaints and I don't know who the aggressor was. The complaint, the officer, there's no way in this world Mr. Mitchell's going to be able to prove who the aggressor was with this complaint unless there's some additional information that comes from somewhere. It's just no way he can do it. And I don't know, there may be probable cause for some kind of a fray, some kind of fighting in public or something like that. But the battery is hitting or touching someone against their will. So I'm not going to find probable cause. I've got to figure out who's going to live where to keep the peace. Are you wanting to have contact with Mr. Griffey?
Yes, sir.
Okay. And do you live together?
For the most part, yes, sir.
When you got arrested yesterday, were you living together? Let's put it that way.
Yes.
Okay. And do you, well, if you want to have contact, it really doesn't matter who owns or rents the home. Yeah. Mr. Mitchell, anything else that you want to be heard on?
No, Your Honor.
Mr. Bowden and Mr. Griffey, I'm going to find no probable cause. I'm going to release you with one condition and one condition only. And that condition is no violent contact with each other. Okay. Yes, so no violent contact with each other. That's a condition of your release. I guess on the RR, I'm not sure if I can even do that, but I think I'm not going to put you on conditional release or a bond with these kind of, that kind of complaint. And I'm not going to hold you 24 hours because your history's not bad and there's no allegation that anybody was hurt seriously. So just no violent contact. We're going to give you a court date, but like you heard me tell the last lady, my suggestion is that you call the clerk's office before the court date, because unless Mr. Mitchell gets some additional information from the law enforcement officers involved, I'm not sure if he can go forward with this case or not. That'll be his call. The court date, Mr. McDaniel, you want to put on would be when?
I don't know if Jake wants to put on June 30th or July 28th. It might be.
Mr. Mitchell?
I should have a decision made by June 30th, so we can put it on that day.
Corporal, please give them a notice for June 30th at 9 a.m. That'll be your court date. Again, to both of you, call the clerk's office like the Friday before court. If the case has been dismissed, you don't have to come. If it hasn't been dismissed, you need to be here. No violent contact with each other in the meantime. Miss Bowden, do you have any questions?
No, sir.
All right, wish you the best. Mr. Griffey, do you have any questions?
No, sir.
Wish you the best.
Jake,
also.
Jake, just to let you know, there's probably not probable cause for a fray either, because it has to happen in public where people see it. Now, I don't think anyone was there. There was on the side of the road. So I mean, take both their testimony against each other which is almost an impossibility. So I know you said they're afraid.
Something just for you, John.
No. I'm just saying, I mean, that would be a difficult case to prove also. So, if you decide to switch it up and charge a fray, I'm gonna let you know that's gonna be difficult too.
Stop digging a hole, John.
Is this early conduct the same statute or different statute?
I think it's a different statute, but it's very similar.
I don't know. There may be something there, but I just don't think it's battery. So we'll let Mr. Mitchell try to figure that out. Mr. McDaniel, that's everything I had on my docket this morning. Mr. McDaniel, anything else from the state attorney, from the public defender's office?
No, Your Honor.
Corporal Drowney.
All right, he's about to wrap it up there. Let's go to Michigan. Judge Jason Elmore. He does Wexford and Missaukee County. He's in Missaukee this morning, so let's see what's going on.
There in Chambers. There's no resolution to the case today. Am I correct again, Mr. Champion?
You are correct, Your Honor.
All right. So we are, however, also here for an alleged bond violation. In this file, the defendant is charged with the offense of possession of methamphetamine as a fourth habitual felony offender. Let's take a look here. Okay, so Mr. Champion, I see here there's a note about there's a motion filed for suppression. Have you contacted the office to get a date set, or what's the status?
We're waiting to get a date. Yes, we've contacted the office because, as the court's aware,
I'm down to one staff member right now.
Exactly. We're waiting
Yep.
for
She's had some medical issues as well this week. All right, well, good enough. I'm gonna leave that up to the defense to go ahead and have it set it for a hearing or coordinate setting it for a hearing with my staff and Mr. Denhout, who of course is the party that bears the burden for the motion to suppress. All right, so now let's jump on to our bond issue. All right, looks like after the case was bound over, this court issued an order regarding the bond. We had an arraignment on that or a show cause. Yeah, it looks like he was arrested actually. The allegation is that the defendant had used methamphetamine and tested positive. And Mr. Champion, am I correct in understanding your intent to the defendant intends to plead?
Yes,
or
Your
admit
Honor.
that?
My client would admit that he tested positive for methamphetamine.
All right, Mr. Barkley, please raise your right hand to the best that you can. Do you swear or affirm that the information and testimony that you're about to provide to this court will be the truth, the whole truth, and nothing but the truth, sir?
Yes, Your Honor.
You may lower your hand. Mr. Barkley, as I told you before a couple weeks ago, you have the right to have a hearing here, and we have to afford to due process and have the prosecutor present evidence to support whether or not there's been a bond violation. But I'm told today you're going to admit to that bond violation for testing positive for methamphetamine because you used some methamphetamine. Is that your intent today?
Yes, it is, Your Honor.
Has anyone made any promises, threats, or inducements to force or compel you to make that admission today, sir?
No, they haven't.
Okay. And has anyone made any promise to us exactly what the court would do in response if you do make that admission? Has anyone told you what I'm going to do?
No, that's right.
All right, thank you. Therefore, Mr. Barkley, let me ask, is it true that looks like back at the end of May, on the 27th of this year, you had tested positive for the controlled substance methamphetamine because you had ingested or used some methamphetamine?
Yes, Your Honor.
All right, did you understand that that was a violation of your bond conditions, sir?
Yes.
All right, thank you. All right, the court accepts that and finds the defendant's admission today is made free of being only involuntarily, and the court further finds that based upon the information presented by the defendant as well as the information presented by the probation officer, Miss Melissa Bismack, who also does the testing when the case was down in district court, that the defendant is in violation of or did violate his bond. The next question here is what do we do with the defendant in the meantime? Let me take a quick look here at what his bond conditions were. All right, the bond conditions as set on, looks like May 1st was a $50,000 cash, I'm sorry, 10% bond. And the defendant posted 25%. He has the conditions of no illegal drugs, random testing. Mr. Denhout?
Thank you. This case has been progressing quite quickly. The original incident date was May the 1st. We would respectfully request that the defendant be remanded pending further proceedings in this matter.
Mr. Chan.
Your Honor, my client has a limited history involving any type of controlled substance in this matter. His guidelines as pleading to count 1, the possession in this case are 0 to 11. I would ask the court to reconsider reinstating his bond and adding the intensive outpatient treatment through community corrections.
All right. Okay, this court will reinstate bond. The court will maintain the original terms and conditions. The defendant is not to use or possess any illegal or controlled substances. The defendant will be subject to random testing, which is now done because this case has been bound over. It's done at the Community Corrections Office over in Wexford County. The court will also add to it that the defendant must enroll at the Community Corrections Office into an enhanced outpatient treatment program. Mr. Barkley, one of the workers from that office, is on the screen. She's up in the upper right-hand corner. Her name is Miss Matsky. She and her manager, Miss Stark, will set you onto that program. And let's be very clear here. I've given you an opportunity for a reason. What do you think that reason is?
Well,
If there were a finding of guilt, I'm not asking you to make any admission, but if there were a finding of guilt, either by a plea or after a trial, why do you think I would let you out?
maybe just to prove myself again, and I promise this time I ain't gonna let you down. I had a problem, but I'm trying to get it taken care of.
Okay, well, you've got part of it correct. I want to make sure that you get some kind of treatment. I want to see that you, if this is actually an issue, that you're getting treatment and you're taking care of it. But I'm also setting the hook. And if you violate, well, then you're going to give me a reason, no matter what, to put you back in jail. Does that make sense?
Yes, Your Honor.
All right, so I'm not making any promises. There's no plea yet today. I've got no idea anything about this case other than what the charges are. But your future's in your hands, and I like to see how people respond to it. All right, thank you very much. We will continue this matter on the court's docket for the next court date, which is currently set for the final pretrial conference. Thank you. We are adjourned. Our next matter.
Let's go to Texas and Judge Boyd.
All right, the court is calling 2024 CR 5218 and 2024 CR 5219, State versus Renee Camarillo. Can I have parties announced?
Jason Garaham for the state.
Marissa Giovanco from.
And are you Mr. Camarillo? All right, you entered pleas in each of these cases on June 10th, 2025. Are both parties ready to proceed with sentencing?
Yes.
All right. And 2024 CR 5219, you entered a plea of no contest to count 1 and count 2. The court found that there was evidence to find you guilty of count 1 and count 2. The court found you guilty of count 1 and count 2. According to your plea bargain agreement, counts 1 and counts 2 were run concurrently, and you will be sentenced to 20 years in the prison. Give you credit for any time served. This is the run concurrent with 2024 CR 5218. Take in consideration 2025 CC 005805. Is there anything else with regards to sentencing and that cause number?
Sentencing.
Okay. And just one moment. Also, there is to be no contact with the following persons: Sarah, SAARAHAMIN is the last name. Tariq, TAREK, last name RAMADAN. All right, and that cause number, did you review the document entitled Trial Court Certification? I'm sorry, one other thing. With regards to sentencing, there's an affirmative finding of deadly weapon in count 1. and an affirmative finding of a deadly weapon in count 2. In that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? Do you have any type of drug issues? Okay. And then in cause number 2024 CR 5218, you entered a plea of no contest to count 1, murder. The court found that there was sufficient evidence to find you guilty, and the court found you guilty. The court will sentence you to 20 years in the prison, give you credit for any time served. This is run concurrent with 2024 CR 5219. And taking consideration 2025 CC 005805. And there's an affirmative finding of deadly weapon. Let's see. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? You need to speak up. All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. How old are you? All right, you're 18. Any time that somebody serves is a lot of time. Many things can happen at the prison. Do not become institutionalized at the prison. You need to realize that you're where you are now because of your actions. I understand with the murder case, the way it's charged, which is legally a way it can be charged, because you were evading, you actually didn't hit the person in the crosswalk. The police actually hit that person chasing you, right? And so when you're sitting at the prison, you're probably going to start thinking, I shouldn't be here. Other people are going to start talking to you saying, you should have done this and that. But what I can tell you, that's the law, right? So at the prison, you can still get your education. At the prison, you can get some kind of trade so that when you're released from prison, you have some ability to get work. And it's going to be hard for you to find employment because you've been to prison. That's why you need to learn a trade at the prison. I don't know if they still do welding at the prison or not. I had one client who went to prison. He ended up becoming a welder. And there was such a high demand for welders, even though he had been to prison. When he was released, he ended up making more money than I made as an attorney. All right. So there's something you can do with your life, but you need to start thinking about the people you hang around with and how you find yourself to be in the situation that you're in. You understand? So there are 2 people who are going to be speaking to you, and this is called a victim impact. So they're going to tell you probably how this has impacted their life. I want you to listen and internalize what they're saying, okay? All right. Watson and Simmons. Let me see if we can get them. Would you call them, please? Because they're in the, here they are.
Yeah, I'm here.
All right, you can show your video if you want to show your video, but you don't have to show your video. Are you able to see Mr. Camarillo?
Yes.
All right. If you want to show your video, you can. If you do not, you don't have to. And you can begin whenever you're ready to begin.
Okay. So my name is, I am the eldest daughter of India Watson. She was one of the victims. She was the victim that actually lost her life, a pedestrian crossing the street. My mom was only 47 years old, with 3 kids under the age of 30 and 12 grandchildren at the time. When I received a call of her death, I was 34 weeks pregnant, and my sister was about 26 weeks pregnant. She never had an opportunity to meet those babies. She would never get to see her grandchildren graduate from college. She would never be able to attend my siblings' weddings when those times happen in the future. This has been extremely traumatizing on our family to not only lose her so suddenly, but in the manner she was killed. Some of the family had to witness video footage of the accident. Law enforcement was going so fast on the night she was killed that my mom was hit at a fast rate where her body flew into the air before it landed on the ground. At the funeral, her face had to be reconstructed for us to have an open casket. She had to be fully clothed with gloves. Ears cannot be shown. The woman who raised me, that I knew to be my mom, I didn't see that woman physically. She was unrecognizable. While I understand you were not driving a vehicle that collided with my mom, you have a role. The actions you played and the things that you did throughout the day contributed greatly to her death. It is difficult to accept that one day you will walk free and have the opportunity to make new memories with your loved ones. Meanwhile, we are left to pick up the pieces of a family torn apart. There is no sentence that can restore what we've lost. We live with the consequences of your actions every single day. The leniency of your plea deal does not reflect the magnitude of the harm you caused. My hope is that you will use the time not just to serve a sentence, but to reflect and grow into someone who values life and considers the pain and reckless choices that you can put on others. Thank you, Your Honor.
Thank you so much. I'm sorry for your loss.
Thank you.
Ms. Simmons?
Yes, Your Honor. Good morning.
Good morning. You may proceed.
Thank you. Thank you for the opportunity. I am the maternal sister of Andrea Watson, and she was the youngest of my mother's 6 children. We certainly did not expect to bury our baby sister at the tender age of 47. There are 5 of us remaining. Andrea had a very large extended family, and she was loved and her life was valued. So it's a great loss to our family. And certainly, as my niece just explained, she had 3 young adult children and now 14 grandchildren. So we have a lot that she left us. But at the same time, those children will not have a grandmother that they can share memories with going forward. This was an unnecessary occurrence. It was an accident, but unnecessary. And I do hope that going forward, this is something that you will think about as you'll have time to visit in prison and think about the impact that you had on a lot of people in our family, certainly. I was very intimately involved in her funeral proceedings. Um, so it was extremely difficult for me. I had a lot of emotional and psychological impact of which I'm in therapy for. And I encourage all of my family to do the same because we have been in great pain for over a year now, and we're still suffering from the loss of our loved one. So it continues to be a difficult situation. The wounds are reopened each time I revisit the details surrounding her death, and there have been many instances since the funeral that we've had to go through writing statements and other things to try to clarify and close out uh, what has happened here. So, with all that being said, I just pray that justice will be served, and that at some point there will be some light that comes out of this dark, dark space that we were thrust into with the loss of my sister. Thank you, Yana.
Thank you so very much. And I hope you realize the impact, the negative impact you've had on other people's lives. Because do you have somebody in your family that you love a lot? Who would that be? All right. Can you imagine what if that was your grandmother just minding their business, obeying the law, walking in a pedestrian, and there is somebody out there driving recklessly, evading the police, knowing that they're in the wrong, and your grandmother got hit? So you need to understand their pain. You understand? All right. Good luck to you. You're welcome. Thank you both for coming in, and you are excused. The advocate will speak to you. Do you need to speak to them? All right. All right, Sop.
All right, let's head up to Michigan. We haven't been here in a week or two. Let's go to Sheila Johnson.
Your Honor, Representative on behalf of the people.
Morning again, Your Honor. Nargis Masimova, appearing on behalf of Mr. Cornell Wright, who is standing to my right.
Hmm?
Can you state your name?
All right.
Okay, good morning, Mr. Wright. You're here for a pretrial on an operating while intoxicated. This is the first offense, 93-day misdemeanor, $500 fine. And you have a driving while license suspended charge as well. First offense, also 93-day misdemeanor, $500 fine. And both of those charges carry driver's license sanctions in the form of points, possible additional suspension of the license by Secretary of State, possible vehicle immobilization. Then you also have a civil infraction here, 1 to 5 miles per hour over the speed limit. All right. And that apparently is in default because you did not respond within the time frame on the ticket. So currently you owe $198 on that. So you understand that. Okay. And you also have a right to trial by judge or by jury on those 2 misdemeanor charges with your counsel representing you as well. You understand? And Ms. Nasimova, how would you like to proceed? This is our first pretrial on these.
Yes, Your Honor, we did receive discovery in this case. We did have a chance to consider this matter with the judge's office. There is an offer that we are going to accept today. The offer is to dismiss all of the original counts, the misdemeanors, and my client would be pleading guilty to an operating while visibly impaired and allowing an unlicensed driver to drive. I should note that my client does have a driver's permit and will be taking his road test.
Okay.
Start, Your Honor.
Okay, so, all right, Mr. Wright, you're going to be giving up your right to have a trial in this matter, and you're going to be pleading guilty to 2 added counts. Operating while visibly impaired is a 93-day misdemeanor with up to a $300 fine, not including court costs. And it also enables you to get a restricted license immediately. And on the other, allowing an unlicensed driver to drive, that charge is a 90-day misdemeanor, carries up to a $500 fine. It doesn't carry any points, and this does not abstract to your driving record at all. So there's nothing for Secretary of State to see if they wanted to take driving license action. So basically, that wouldn't affect anything. And if you're in the position to get your license, they won't be looking at that. Okay. And we'll dismiss the original 2 misdemeanors. So is that what you like to do?
Yes.
All right, let's go over all of the constitutional rights that you do have at trial that you are now getting ready to waive because you're pleading today. And if you understand these rights that you're giving up, all you need to do is say yes as we go over them together. So we're going to start with the fact that, again, you have a right to trial by judge or by jury with a lawyer. You understand you're going to waive that.
Yes.
And at that trial, you have a right to subpoena witnesses, which means you have a right to ask court to order witnesses to come forward to testify. You understand you're waiving that. You have a right to question through your lawyer any of the witnesses brought against you by the prosecution. You're going to waive that. You have a right to testify on your own behalf at a trial, but if you chose not to, no one can hold that against you. You understand you're going to waive that. Also, I have the right to be presumed innocent unless proven guilty beyond a reasonable doubt by the prosecution. You understand you're waiving that.
Yes.
You're on probation or parole and you plead today. The plea might be considered a violation of probation or parole status because it might be considered a new case. So you understand that. And you read and signed this full advice rights form and went over it with your counsel. Have any questions? All right. Understand then if I do accept the pleas today, you will not have a trial. You'll give up the rights on the form.
Yes.
You also understand the penalties involved with the charges that you're pleading to. And you still wish to plead to allowing an unlicensed driver to drive and operating while visibly impaired.
Yes.
And you understand if you wanted to appeal anything, you'd have to try to appeal and have a right to appeal or either request permission to appeal within 21 days of being sentenced and request a lawyer for an appeal within 14 days if you wanted to have a lawyer for an appeal. So you understand that.
Yes.
Anybody force or threaten you to give up your right to have a trial? Anyone promise anything other than what we stated on the record? And you're pleading freely and voluntarily, is that right? All right, if this offense occurred, let's see, this would have been on or about November 23rd, 2022. Were you operating a motor vehicle upon M10, the Lodge Freeway, the portion of which runs through the city of Southfield?
So,
And while you were operating your vehicle at that date and location, were you under the influence of some type of alcoholic beverage at the time?
yes, I will.
And do you remember what it might have been that you had ingested? What you drank?
1738.
Ooh, 1738. What kind of alcohol is that? Cognac. Okay. Based upon your consumption of the cognac, like your ability to operate your vehicle was impaired. Okay. And do you know what the breathalyzer, did he take a breathalyzer or was it blood?
He did. It's 0.11, Your Honor.
Mr. Shockley? Okay. And sir, same date location when you were operating that vehicle in the city of Southfield on M10 Lodge Freeway, you wish to plead guilty to allowing an unlicensed driver yourself to operate that motor vehicle?
Yes.
All right, people satisfied with that?
All satisfied.
Satisfied.
The court's also satisfied factual basis here for the plea. Believe the court rules have been complied with, and I will accept each of these pleas, finding that they are freely, understandably, voluntarily, accurately, knowingly made. And we'll go ahead and dismiss the operating while intoxicated charge, as well as the driving while license suspended. Okay. Mr. Shockley, you doing anything with the civil infraction?
I'm dismissing the speeding.
Okay. Speeding ticket also is going to be dismissed, so you won't have to pay that $198, sir. That sucker didn't help him. 6, 12, 13, right? Okay, so the next step in this process is we're going to send you down to the probation department today to get a date to come back to them for an interview. They are going to prepare a full background report. So also assess or give you a alcohol assessment test. So when you finish that, they will have 2 reports there. You'll get a chance to review them with your lawyer prior to sentencing. Then I'm going to use those and anything else that you may choose to submit to determine what the proper sentence should be. So make sure you don't miss that, interview, because then we would have to adjourn your sentencing. Okay. So the sentence date to come back to me will be
July 16th at 9 a.m. That works.
July 16th. Okay, 9 o'clock on July 16th. Fine, it's gonna be continued. And she'll give you, somebody will give you a notice for the new date for sentencing, and then court officer would take you down to probation so you could get a date for them. You can't reach that one.
Almost.
Okay. All right. Let's see. Case number 25BF00220 People State of Michigan versus Eunice Black. Eunice Black.
Your plea deadline.
Let's actually go back to Judge Boyd.
All right. So if you will, do you want a jury trial or a bench trial? Let me explain something to you. We're in the middle of a bench trial right now. At a bench trial, I make the decision. I'm basically the jury. And what I can tell you, if the state proves their case beyond a reasonable doubt, I'm going to find you guilty. If they don't prove their case beyond a reasonable doubt, I'm going to find you not guilty. For the court, if it's a murder case, if the state proves their case beyond a reasonable doubt, I'm going to find the person guilty. If they don't prove their case beyond a reasonable doubt, I'm going to find them not guilty. So for the court, I don't pay any attention to, oh my gosh, this is a murder case. You can't find somebody not guilty. But if you want a jury trial, we will get you a jury trial.
We'll look at her.
All right, Norma.
Yes, ma'am.
State,
Yes, Mr.
do y'all want to, he's requesting a day. If we do a jury selection on Wednesday and everybody's able to have their witnesses on Wednesday, it should be done on Wednesday. All righty. Yeah, we can just put it on.
So I know the
We're okay with all the other.
All right, you can put it in Jill, Norma.
So I do have a vacation letter on file. 23rd.
Norma, you want to put it on that first week in July? July 7th?
Yes, ma'am.
All righty. All right, she'll be back for jury trial on July 7th.
Thank you, Your Honor.
All right, and I need an acknowledgement of discovery. And so state on that one, we can, since it's coming back on July 7th, we can pick a jury maybe in the afternoon and then do the testimony or whatever in the afternoon on Tuesday. All right, thank you. All right, thanks.
Yeah, I'll get you.
Let's stay in Texas, but we'll head west. This is El Paso, and this is jail magistrate court. Let's see what's going on there.
Email address?
Yes, ma'am.
Okay.
DXR gmail.com.
And do you have a phone number for a friend or relative?
Not off the top of my head, ma'am.
Okay. Thank you, sir. Thank you, Judge.
Thank you, sir. Have a good day.
Thank you, Your Honor.
Ricardo Lucio.
Yes, Your Honor.
Good morning, sir.
Good morning.
Give me a second. I'll be with you in a second. Okay, Mr. Lucio is here on a possession with intent to distribute a controlled substance anywhere between 4 but less than 200 grams. Risk assessment level of a 3. Multiple misdemeanor convictions involving driving. Multiple convictions for DUI. 1, 2, 3, 4, 5, 6. 6 arrests, some convictions, some dismissals. And he says he's got $300 for bond. Ms. Quevedo?
Thank you, Judge. Sorry, my spreadsheet is being slow. Did you say Haskins?
Lucio Ricardo. Lucio is the last name, bottom of page 4.
Oh. Judge, Mr. Lucio said that he lives at 10812 Onyx Stone with his sisters. He's lived his entire life in El Paso. He went to Burgess High School where he completed up to the 11th grade. He has his sisters, his brothers in El Paso. He still maintains that he has about $300 that he can post. So he is respectfully requesting a bond reduction or a split bonds, whatever relief, if any, the court should find fitting. Thank you, Judge.
Ms. Zavala?
He also has records from California. This incident occurred June 11th of this year. We haven't screened this case. EPPD conducted a traffic stop of defendant's Honda vehicle for failing to signal, and that's in the area of 100 block of Newman. It's a high crime area for narcotics distribution. Defendant could not provide an ID and proof of insurance for his vehicle. Defendant was the sole occupant driver of the vehicle, and he consented to a search of his vehicle. Officer then observed in plain view on the front passenger seat a clear plastic baggie with white-like substance that tested positive for cocaine. There was also a cigarette box which contained 2 clear plastic baggies inside. The baggies were cocaine, and altogether they tested positive for cocaine, 18.6 grams.
Mr. Lucio, I'm going to reduce your bond to 5,000 cash corporate surety, no PR component. Understood?
Yes, Your Honor.
All right. Thank you very much. Have a good day, sir. Mr. Diaz has been waived. Are you Mr. Olivas?
Yes, Your Honor.
Good morning, Mr. Olivas.
Good morning, Your Honor.
All right, Mr. Olivas is here on evading arrest or detention with a motor vehicle. $30,000 bond, risk assessment level 4. He is currently on deferred adjudication for smuggling of persons for financial gain and possession of drugs. He's not sure how much money he has for bond. Ms. Quevedo?
Thank you. Mr. Olivas, if you're released from jail, where would you live?
235 Archangel. That's in Chaparral.
Okay. And how long have you lived in the El Paso County area?
20 years.
Are you a U.S. citizen?
Yes, ma'am.
What is the highest grade of school that you finished?
I graduated.
From high school?
Yes.
Okay. Chaparral High School or Gadsden?
Here's a pride.
Do you, what family do you have here in the area?
My mom and my grandparents.
Okay. Do you have any amount of money that you can post toward
I'm
your bail amount?
not sure, to be honest.
Do you have a phone number where you can be reached if you are released?
Yes.
What's that number?
915.
Thank you, Mr. Olivas. Your Honor, based on the information provided, we're respectfully requesting a bond reduction or a split bond, or of course, full PR bond, whatever relief, if any, the court should find fitting. Thank you, Judge.
Ms. Zoella?
We haven't screened this case. This is an old case from last year, April 12th. DPS Trooper Lima was on US 54 and he observed Fence vehicle, a Nissan bearing New Mexico license plate that was traveling inside the left lane for 2 miles without moving over. And there was a sign on that lane that indicates left lane was for passing only, and that's a violation of the cause for the traffic stop. Defendant failed to stop and continued to travel, exceeding his speed over 100 miles per hour. Trooper Lima chased the defendant for about 20 miles with no sign of stopping. Eventually, defendant pulled over and was taken into custody. And by the way, the one that you mentioned that he's deferred his on deferred adjudication for 2 counts of smuggling and 1 count of possession SPG1 less than 4 grams. That was only from May 22nd of this year. And there's 1 pending unfiled possession CSPG1. He was arrested for it on February 22nd of this year.
Okay. That was before he was placed on probation, right? He just pled guilty on May 22nd, 2025.
That's right.
All right, Mr. Olivas, I'm gonna reduce your bond to 5,000 cash corporate surety, no PR component. Do you understand?
Yes, Your Honor.
All right, thank you very much. Have a good day, sir.
Thank you. You too.
Let's try something new, at least new for this channel. We'll go to Butler County, Kansas. We've been there before, but this is Judge Charles Hart, who we have not seen before. He is doing pre-trial plea dockets. Let's see what's going on.
PR 119 in its entirety.
Thank you, Mr. Regier. Mr. Barringer, Mr. Watts has advised the court that you do wish to enter a plea of guilty in case number 25 CR 117, count 1, possession of methamphetamine. All other counts would be dismissed. In addition thereto, case would be dismissed in its entirety by the state, 25 CR 119. Is that your understanding of the plea negotiations?
Yes, Your Honor.
There are a number of questions that I do need to ask you in order to ascertain whether you are knowingly and voluntarily entering your plea. Sir, how old are you?
27.
Are you married or single?
Single.
Are you employed?
No, not at the time, I'm not, no.
What type of work have you done in the past?
I worked in a pulling unit in the oil field.
What is the highest education level you have obtained?
12th.
Are you making your plea voluntarily?
Yes, sir.
Have there been any promises or threats made to you which have influenced you to plead guilty?
No, sir.
I understand there have been certain plea negotiations entered into between your counsel and counsel for the state. Do you understand even though the attorneys may make certain recommendations in regards to sentence, the decision in regards to appropriate sentence is mine pursuant to the sentencing guidelines for the state of Kansas?
Yes, sir.
When you plead guilty, you surrender and waive certain legal rights you would otherwise have if you chose to go to trial. Do you understand you have the right to a speedy trial where your guilt or innocence would be determined by a jury or if you chose to waive a jury by a judge.
Yes, sir.
Do you understand in such a trial, you'd have the right to confront the witnesses against you and have them cross-examined by your attorney?
Yes, sir.
Do you understand in such a trial, you'd have the right to subpoena witnesses who may have information favorable to you and call them to testify in your behalf?
Yes, sir.
Do you understand in such a trial, it would be the burden of the state to prove your guilt beyond a reasonable doubt on each element of the charges against you before you could be found guilty?
Yes, sir.
Do you understand the judge and the jury must presume you're innocent until the state proves otherwise, if ever, beyond a reasonable doubt?
Yes, sir.
Do you understand if convicted at such a trial, you'd have the right to ask the court for a new trial, and if denied, would have the right to appeal your conviction and your sentence to the appellate courts of the state of Kansas?
Yes, sir.
Do you understand you're giving up each one of these rights if you plead guilty?
Yes, sir.
Do you understand the sentence which may be imposed?
Yes, sir.
You may be sentenced anywhere from 10 to 42 months in prison. If you would have a criminal history of 3 or more non-person felonies or less, there is a presumption you would be placed on probation. If you would have a criminal history of 1 person and 1 non-person felony or 1 person felony, you would be placed in a border box whereby it would be at the discretion of the court whether you're placed on probation or in prison. If you would have a criminal history of 2-person felonies or more, there is a presumption you would be placed in prison. As you appear before the court today, I do not know what your criminal history is, if any. You would best know what your criminal history would be. Do you have any question as to the sentence the court may impose?
No, sir.
Do you understand that in addition to the possible sentence and fine, the court will order payment of court costs? I may require you to pay restitution for any personal injury or property loss. I may impose administrative cost of a probation program and may require you to reimburse the state for your indigent legal fees.
Yes, sir.
Daughter, that's pretty good. I like the third. That's nice. Your dad did that for you?
Have you ever been a judge mentally ill by a court?
No, sir.
Ever had a guardianship or conservatorship set up to handle your affairs?
No, sir.
Are you presently under the influence of any intoxicating liquors or drugs?
No, sir.
Have you had plenty of time to discuss this case with your attorney?
Yes, sir.
Would you like any more time to talk to Mr. Watts about the matters we've just discussed?
No, sir.
Keeping in mind all matters we have discussed, is it still your wish to plead guilty?
Yes, sir.
When you plead guilty, you're saying that you did in fact commit the crime of possession of methamphetamine. Is that correct?
Yes, sir.
In your own words, tell me what you did.
I got pulled over and they searched me and I had methamphetamines on me in El Dorado, Kansas.
Did that occur on or about March 14 of 2025?
Yes, sir.
And you were in El Dorado, so that's in Butler County, Kansas. Is that correct?
Yes, sir.
Do you know of any reason why the court should not accept your plea?
No, sir.
And Mr. Watts?
No, sir.
Mr. Berringer, the court does find that you are alert and intelligent, that you understand the nature of the charges and appreciate the consequences of pleading guilty. I further find that you understand the rights you're giving up by pleading guilty. I do find the facts of the case to be sufficient to sustain a guilty plea. I further find your decision to plead guilty is freely given and that you have had the advice of a good attorney with whom you are well satisfied. Therefore, I do accept your plea of guilty to count one only, possession of methamphetamine, severity level 5 drug felony. Court grants the motion of the state to dismiss all other counts, and the court does grant the motion of the state to dismiss case number 25 CR 119. the court does set your case for sentencing. This would be on Thursday, September 18, 2025 at 1:30. Thursday, September 18, 2025 at 1:30. That will be conducted by Zoom process. Subsequently, the court does order that Mr. Watts contact court services after the pretrial conference plea doc today so that they are able to schedule appointment for you for the pre-sentence investigation report. Any other matters to come before the court, Mr. Regier?
Forgive me, Your Honor, I had been temporarily experiencing certain technical difficulties. The state would request that the court again clarify what date the sentencing hearing is to be scheduled for in this matter.
Sentencing would be September 18, 2025 at 1:30. September 18, 2025 at 1:30.
Thank you, Your Honor.
And Mr. Watts.
I don't believe anything else, Your Honor. Mr. Berger, are you still subject to that parole hold?
Yes.
Okay. There being nothing further to come before the court is in recess. Mr. Berger, have a good day.
You too. Thank you, Your Honor.
And Your Honor,
Yes.
forgive me, I should have addressed this previously. Is the court continuing the bond in this case?
Yes, court continues the bond in the case.
Thank you, Your Honor.
So when so many of the regular courts that I monitor are doing things like landlord-tenant, or Judge Boyd is back to her bench trial, so it doesn't make sense to go there because we don't have the context, it affords us the ability to jump around and try some new things a little bit more. So let's do this. Let's go to Lawrence County, Ohio. This is their municipal court. To be honest with you, it looks like they're holding court in like a basement or a dungeon or something. But let's check it out because I haven't really done it before.
Well, warrant has been outstanding for Ms. Mills for a while, and she left prison.
I think February 28th, Your Honor.
March, I think it was.
February, I think, was when she felt to appear for court.
She left prison in March 6th.
Yeah.
So what's, yeah, I mean, proposals, what you want to see happen, or?
Your Honor, they'll take her back. Maybe we can put an ankle monitor on her and do that. And that would be, like you say, far worse situation if you would cut that off or take it off. So
what's the safe's position?
She was back in court on a probation violation, is that right?
Well, some of these are, yeah, it looks like they were probation violations.
Yeah, she probably had no contact order that was in place from, well, I mean, I still think that there may be actually another charge involving.
New one coming?
It may be, I'm just being told that. Yeah, where is that charge now? We just got a report or something. I wonder if she's been arraigned on it. Is there a new charge?
I don't have, is it here, would it be in this court?
Wait a minute, maybe I don't understand.
Her father got a charge, I arraigned him yesterday.
Okay, that's what it is. Oh, all right. Well, obviously GPS is an important component of this since she disappeared for a long period of time, but if they will take her back and she has the monitoring, I think we'd be okay with that.
and it sounds like we might not have any monitors for a minute, so.
Put it on Monday.
Put it on Monday. Yeah, I'm here Monday.
June 16th will be the next hearing. I'll look to try to free up some monitors out in court today. Thank you.
State of Ohio versus Jesse Lee Friend, case number CRA 25355, and Derek Jenkins is on deck.
Sir, are you Jesse Lee Friend?
Yes, sir.
Mr. Friend, it's alleged that there's a warrant for your arrest in Mason County, West Virginia, and they're asking that you be extradited on these charges. Looks like 2 charges: willful and intentional removal, injury to, or destruction of property of more than $2,500, fleeing from law enforcement in a vehicle, and showing reckless indifference to the safety of others. Those are the 2 charges I'm informed that you have in Mason County, West Virginia. You have a right to what's called an extradition hearing in this court to determine if you are the Jesse Lee Friend that's sought by West Virginia authorities, and if I should order you to go to that jurisdiction on these charges. You have a right to have that extradition hearing and to have an attorney appointed to represent you at that extradition hearing if you can't afford one. The other option you have is you can agree to go to West Virginia and face the charges, and that means you're waiving the extradition hearing. And it doesn't mean you're admitting that the charges are true, you're just giving up your right to contest the return or being sent to West Virginia. How do you want to proceed, sir? Do you want a lawyer in this court, or do you want to agree to go to West Virginia?
A lawyer in this court, I would imagine.
Okay. Do you have a job?
No, sir.
You have no income?
No, sir.
All right. I'll appoint Mr. Smith, Roger Smith. He's a West Virginia lawyer as well, so he's got license in both Ohio and West Virginia.
Okay.
So this would be the court, and they ride a circuit, don't they?
Yes.
Point Pleasant and
They don't, Putnam maybe sometimes?
yeah.
They come, yes, they do. They have different.
Okay, so I'm going to appoint Mr. Smith to represent you. This sounds kind of serious on both of these charges, so I'm going to set a bond of $5,000 cash or surety. So if you got $5,000 cash that you can post with the clerk and do that, I'll release you and order you to go turn yourself in Mason County, West Virginia. If you do it, and that gets confirmed, the whole $5,000 gets returned to you. If you cannot post the $5,000, you can use a bail bondsman. You have to pay them a fee, and you lose that fee. But then if you don't go turn yourself in, they're going to track you down because they don't want to have to forfeit the $5,000. Do you think you can post a bond either by cash or surety?
No, sir. Is there any way I can get a bond reduction?
Well, you can talk to your lawyer about it.
I'll call down and talk to you here in just a few minutes. Okay. And I would ask the jailer to keep him close by because I'm literally going to call in the next 5 minutes.
Okay. I'll put it on the docket. Let me see what we got here.
Okay.
Not Monday, it's terrible. I'll set it for June 20th.
That's fine.
But if he decides today he wants to waive, he can bring it back.
We will have a discussion. Yes, sir.
June 20th will be, the next hearing will be a pretrial at 10 o'clock. Here's the court's file. Your lawyer's going to call and talk to you on the phone.
Yes, sir. You have a good day.
Too.
State of Ohio versus Derek A. Jenkins, case number CRB 25356.
So we'll stick here for one more case just because I'm intrigued by this room. You tell me in the chat, but I feel like these walls could tell stories. This seems like the perfect Friday the 13th courtroom to me, but let me know in the chat.
Yes.
Hey, Derek Jenkins, is that you, sir? Derek Jenkins, can you hear me?
Yes, sir.
Mr. Jenkins, I'm Judge Capper at the Lawrence County Municipal Court, which is in Chesapeake, Ohio. This is your what's called your arraignment hearing. You are appearing in the court on a monitor, and your image and what you say is being recorded, and everybody that's in the courtroom can see it. You have a right to remain silent. You don't have to say anything. If you do make statements, it's all on the record. It can be used against you when it's being recorded. You have a right to have an attorney, to have one appointed if you can't afford one, to have bond, and to make the state of Ohio prove the charge against you beyond a reasonable doubt. Do you understand that?
Yes, sir.
You're charged with domestic violence. It alleges on June 12th, 2025, you knowingly caused or tried to cause physical harm to Heather Jenkins. That's a first-degree misdemeanor, domestic violence charge, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir.
Do you understand your rights?
Yes, sir.
How do you plead to this charge?
Not guilty.
You want a lawyer appointed to represent you.
Do I have a lawyer?
Do you want me to consider appointing you one? If you don't have enough money to hire one, and you meet the guidelines, I can appoint one. If you have plenty of money, then I can't appoint one. You have to hire your own.
Yeah, I'd rather go.
Do you have a job?
Yes, I have a job.
Where do you work?
All in one concrete.
Are you paid by the hour?
Yes.
How much?
I'm paid by the day. $300 a day.
How many days a week do you work?
About 3 at the least.
I have to determine your gross annual income. So, do you file an income tax return?
Yes, I have a 1099 every year, but my job is seasonal. It's like I say, I work 6 months out of the year.
What does your 1099 show?
When is it due?
What does it show? What does it show your annual income is?
Like 40,000 a year.
Do you have children?
I have stepchildren, yes.
Well,
no biological, no.
okay, you don't qualify for court-appointed counsel. I'm entering a not guilty plea for you. What's the state's position on bond for Mr. Jenkins?
Your Honor, if it please the court, it's reported that Mr. Jenkins was arrested in Ironton after this happened, and the report indicates that he was also in possession of something, narcotic of some sort. So there's probably
going to be charges there too.
It looks like it. So, given that, just for the time being, we ask for a $2,500 cash or surety bond, and then we'll figure out, and we're also going to want a protection order, of course.
Mr. Jenkins, do you have someplace you can go live other than with Heather?
Yes.
Where would that be?
My parents' house.
Who are your parents?
Piketown, Ohio.
Who are your parents?
Who was it?
Yes, sir.
Darren and Brother Jenkins.
And they live in Piketon?
Yes, sir.
You know the address?
It's 1050 State Route 220, Piketon, Ohio.
Okay.
4
I'm going to set your bond at $2,500 cash or surety. The prosecutor is alleging there's going to be additional charges coming on you for some sort of narcotics violation, it sounds like.
That's what it indicated in the report.
Okay. But I'll let you out on a bond, so if you can post $2,500 cash with the clerk, you get it all back as long as you come to all your hearings at the end of your case. If you can't post $2,500, you can hire a bail bond fund and pay them a fee, and then they're guaranteeing you show up. And if you don't show up, they'll come snatch you up and take you to the jailhouse.
Can I ask you a question about how this happened?
No?
Like what
You can
happened?
ask the question, but I'm not going to answer it. That's not.
Right, well, I got I got hit with the drill, like she threw a serve,
Sir, you're out of order. We're not gonna talk about what happened.
You're telling me to shut up?
I am. If you wanna put it that way. Okay, I'm finding you in contempt. You're sentenced to 15 days in jail. Cancel the warrant, the bond. I'll set your next hearing a week from today, and you will be in jail till then, June 20th, at 10 o'clock.
Okay, so I was gonna cut to something else, but I kind of want to stay here. Put a 1 in the chat if you want to stay here a little while longer. This place is weird. Just let me know. 1 in the chat if you want to stay here.
I need an order on the contempt. Okay.
Okay, the crowd has spoken. We'll stay here for a while. This is the perfect Friday the 13th court, I think, but let's keep going.
25-273, A&B, Mr. Travis case.
That's not his Steyer.
I'm
It's
sorry.
Mr. Steyer's case.
Oh, okay.
Jordan Williamson. There's been some money's paid into the court. But that's part of it. It was a bond and it's like a bond was supposed to.
I don't think there were any old cases pending with this. I thought it was just the new case. I've not seen Mr. Williamson today, however, Your Honor.
Judy Goodman posted $1,250 cash bond for Jordan Williamson.
Your Honor, I have contact information for Mr. Williamson. I know you normally would allow 7 days before a warrant. I'm not going to be here on 7 days from now, but I'm going to try to get a hold of him and ask him to be here for Monday if I could.
Okay. I'll go ahead and start the process. He's got 7 days to come in. If he's here Monday, there won't be a warrant issued by then. And the bond's going to be forfeited if he doesn't show up.
What date, Your Honor? 6/20, what did you say?
I didn't continue. I just want to go ahead and issue, start the process for a warrant. But if he comes in Monday, the warrant won't have been issued by then. And we'll recall it then. Might want to get all too. I don't know who that person is that posted this bond for. They're going to lose their money.
It's a phone number, Your Honor, we'll do that.
Okay.
State of Ohio versus Kayla Harris, case number TRD 21-1692, CRB 21-209.
This is Mr. Steyer's case.
When did you do that last? What did you take the test? Was it the written or driving? Okay. Your Honor, the main thing that's holding us up at this point is Ms. Harris is attempting to get her license back. She took the written test last week and did not pass that. She's studying to try to take it again. I believe everything else has been dealt with except this driving under suspension ticket. And if it were to go in without her getting her license back, it's going to lead to an additional suspension, which would obviously hinder her a great deal. Although I realize we're taking up time on the court's docket. I think it's probably worth allowing her some more time to try to do that. I think the goal of getting licenses back is probably.
They have, well, I don't know if they have a booklet anymore. Back in ancient times when things were in paper, they had a little booklet. You have to read the booklet if you want to pass, because they ask you crazy stuff like what is the minimum tread depth that you can have on a tire to be legal. You're not going to know that unless you read that booklet. It's like 30 seconds or something.
Yeah, I bought,
If you read it, you're going to know it.
I bought 2 books from Walmart, the study guide, so I hope I have the right books.
Is there a time limit on how often you can take the test, or is anything like that? Is it like they say you have to wait a month or anything like that?
I think I can take once a week.
Okay, I just want to make sure we weren't going to come back before she was even allowed to take it again. I'm here. Oh goodness, I have a lot of days that I'm not here coming up. I'm here the 27th. That may be a little optimistic, but I've got a bunch of jury trials and things right after that, so it's going to be difficult to get anything scheduled.
June 20, 2 weeks, June 27th. Next hearing. Pre-trial, 10 o'clock.
Thank you, sir.
And Your Honor, I do have court in West Virginia that day as well, but that's at 9 a.m. and it's magistrate court, so I think I should probably be over here. That usually doesn't stretch out too long.
State of Ohio versus Carolyn Jacks, case number CRA 25341.
Carolyn Jacks is Mr. Morford's case. She's ODP, I hope, that's what she's supposed to be.
That's what we arranged at the marathon last Friday, Judge.
That's all right, this Ms. Jacks is appearing by teleconference.
Does anything, sir?
You're Carolyn Jacks,
Yes, yes.
and you're an ODP.
Yes, I'm going right now.
Okay. And how much longer are you supposed to be there?
I'm not sure, Judge. I assume, I don't know. It's whatever you say.
Okay. Well, that's different, because usually they have a date they want to kick you out by, so.
They pick me up on Monday evening.
Okay, this past Monday, the 9th? Well, you're probably going to be there for about at least a month, so why don't we come back and say 3 weeks? Are you here on July? Can you be here on the 3rd?
Yes.
That's a Thursday. Because the 4th is, July 4th is Friday.
That'd be all of that. So,
Your lawyer's checking his schedule.
I'm free in the morning, Judge, on that day.
Okay, July 3rd is going to be your next hearing, ma'am.
okay.
You can appear, as long as you're still at OVP, you can appear by teleconference. A lot of times they bring people, so if Brianna's here, she'll probably bring the report. She's not here today. Okay, July 3rd, stay in treatment like you're doing. We'll see you again, 10 o'clock.
Thank you, Lord.
Thank you.
You're welcome.
Thanks, Judge.
Good Butch.
State of Ohio versus James P. Badgett, case number CRA 2525 A and B.
This is Mr. Smith's case. We're looking for a report.
Yeah, Fred, John.
Yeah.
Angela?
They're still not emailing.
It's a positive report.
Yes, sir.
Looks like he's still going to continue with ARC, so we set another date.
Mid-July, what's your schedule?
Any Friday, Your Honor?
18th?
That's fine.
July 18th, the next hearing.
10 a.m.?
Yes, sir. Continue what you're doing.
Thank you, sir.
State of Ohio versus Jonathan Gibson, case number CRA 2597, CRB 2598.
Smith's case, preliminary hearing, pre-trial. Well, he's already pled guilty to the misdemeanor. We have a felony.
May I approach, Your Honor?
Yes. Is that what that is? Good report. Sounds like you're learning some stuff and working on things.
Absolutely.
Good job. And you stayed. I took the monitor off of you and you didn't run.
No.
So that's good. Same date?
That's fine, Your Honor.
Next hearing is July 18th. Keep up the good work, Mr. Gibson.
Absolutely. Thank you very much.
Thank you, Your Honor.
You're welcome.
State of Ohio versus William E. Hargis, case number CRA 25178.
Your Honor, back on the 9th, Mr. Argus had a assessment done that said no services were needed. You had him test or attempt to test that day. He was unable to. And he spent that.
Did you test today?
I have not.
Okay.
I was getting to that, but I didn't miss that. Well, that's alcohol THC. All right. This is a felony, Your Honor, so, I mean.
You want to try it again and be honest with the folks when you go back for your assessment?
Well, I've told her that I've done marijuana.
Well, you tested for alcohol and marijuana, but, I mean, we could just send it on to the grand jury and let them deal with it. If you don't want to get treatment, that's probably the best option. Maybe they'll let you come in and testify in front of the grand jury, and you convince some of your fellow citizens here in Lawrence County that you don't need advice.
Well, she never say anything. I've been going to OPC, OVP, whatever.
You are now?
Yes, sir, I'm still going through her.
Well, I can't verify that because we don't have anybody here from OVP for that.
Your Honor, we do have.
Oh, we do, okay, sorry. I didn't, no,
I'm still saying
ain't.
ain't.
She wasn't here. You brought Mr. Keplinger?
Yes.
Okay, thank you for that. You probably don't know anything about Mr. Hargis, though, do you?
No, I work at the inpatient center, but I can find out.
Yeah,
Okay.
let's recall it.
Yeah, why don't you do
Yeah,
that?
what's
We'll
the name?
recall it. His name is William E. Hargis,
Okay.
Hargis.
Okay.
We'll recall it. Thank you, ma'am.
State of Ohio versus Arthur W. Williams Jr., case number CRA 25324, BRC 131736.
Mr. Stratton's case.
I do have a letter from OVP from Mr. Williams.
Okay.
It's kind of a weird letter, so, yeah, it talks about an assessment, and then it talks about nothing else about the assessment, so.
Okay.
She's gonna come back on Tuesday.
Yeah, it's kind of weird, letter.
Well, I take it to mean that he must have taken some kind of test, but and they thought it was inconclusive, and they sent it out for further lab work, I would think. So
Yeah.
they sent it out for verification, so.
Yeah, but he went there to get an assessment that there's no, hey, he's assessed for this. It doesn't say
Right,
anything
it's
about.
very vague.
Yeah, it is.
What's the state, and his is a felony too, so.
His is, this was arraigned on the 30th of May, so this is our first, he was to go get assessed, and so I just think maybe we set in a couple weeks and then, see what OVP says about that. When are you supposed to go back?
Well,
to
one thing I would tell
Tuesday.
them, I mean, you were charged with possession of methamphetamine. I don't know if you told them that, but you might tell them that, and maybe that would change their mind about what, if it's inconclusive on their assessment, so.
Well, Your Honor, he did tell them that, so.
Okay. So when did you want to come back?
Whenever's convenient for the court, he's going back over there on Tuesday, so. See if
Well, you said you weren't available on the 3rd, right, or July?
that week I'm not, I'm out of town.
Soccer camp of some sort.
Regionals in DC, yes, yeah. It's always soccer, Your Honor.
How about the 7th of July?
And I have a trial that week, Your Honor, I'm sorry.
The whole week?
It's a murder trial, so I expect it to be a 5 days.
14th?
14th will work, yes.
Okay, July 14 will be the next hearing, 10 o'clock.
All right. Hey, just ask her for a little bit more detail on that letter. Okay, thanks.
State of Ohio recalls Jesse Lee Friend at the Lawrence County Jail, case number CRA 25-355.
Mr. Smith's case on an extradition issue.
Correct, Judge. I spoke with Mr. Friend. I also got a hold of Gary Sanders. Mr. Friend believes he can post a bond in the amount of $5,000. Has Gary gotten a hold of you yet? He told me a little bit ago he's trying to get a hold of you.
That's sir, I got a number right here for you, that's gonna pay it.
Oh, you have somebody that can pay it?
Yeah.
Okay, well, Mr. Sowers would handle that. I mean,
Yeah, for here, that's well,
You want to give Mr. Smith the number and he can pass it?
I can't because I'm in communication with Mr. Sowers right now. He's trying to get a hold of you. What is it? The number?
740.
Yes, sir.
285. 3811.
3811. Can we recall this, Judge? Or I can get hold of him now, but I don't know how soon he'll get me back.
Who is this person, the number you just gave?
My sister, her name is Samantha Friend.
Is she local?
Yes.
Okay. I'll get Gary right now, Judge, if you want.
Well, if he's...
You feel confident she'll do it? Have you already took your sister, I guess?
She's just finding out where it's going.
Okay. Then, Judge, I think we're good, actually. Because
Okay.
Gary said he will write the bond. He just hasn't had a chance to communicate. If he's got somebody.
You want him to go ahead and sign the waiver then? Or?
Yes. Well, what we're going to do, we talked about, I'm going to send a waiver up. That way, Mr. Sanders will post the bond. You can turn yourself into Mason County. Is that what you want to do?
Yes, sir.
Okay. Yes, Judge.
So I'm going to give you a week to turn yourself in. You've got to turn yourself in before 8 a.m. June 20th.
Okay.
And he would go to Point Pleasant,
Yeah,
right?
Point Pleasant is correct.
To probably the sheriff's office.
Yes. It's right there. It's right attached to the courthouse, the sheriff's office.
And then if for some reason you can't get there, you have to appear in this court in Chesapeake that day at 10 a.m. Otherwise, a warrant will get issued from this court for you.
Yes, sir.
I will be here Friday, next Friday, Judge, in that event.
And do you have his other contact information?
I think I might have another call, but go ahead and give me, what's your good phone number again? I think I've got it at the office, but what is it? Remind me. Yes, sir.
740.
Right.
648. 5190.
Up with you, make sure you got a hold of Gary, everything's done, and you've turned yourself in, okay?
Okay, yes, sir.
All right, you got to do it.
Yes, sir.
All right.
Okay, we're gonna send a waiver down for you to sign, just saying that you will go turn yourself in within the next week after point closed. You understand that?
Yes, sir.
And if you don't, you have to appear in Chesapeake and explain why you didn't do it.
Yes, sir. Okay.
Let me ask you this, what is your sister's name, so I can tell Mr. Sowers?
Samantha Brown.
Samantha, okay, thank you.
We're finished with Lawrence County Jail.
Okay, that finishes up at the jail, so we're back to hearings here in court.
State of Ohio, State of Ohio versus Automates Clark, case number TRC 25707, A, B, and C.
Clark is Mr. Smith's case, it's preliminary hearing and pretrial. She's in Land Goshen.
She said Tuesday, so we can
Major Springs, looking for work at this time. Complying with the
Honor, she has been in contact with Ms. Dalrymple at QRT. She's considered, they have a meeting formally on Tuesday. I don't know if you want to set this Friday, how busy next Friday is.
It's not too bad.
If we could do that, she'll have a chance on Tuesday to speak to Ms. Dalrymple about the QRT program.
All right, we'll pass or just set for another hearing on June 20th to decide if she's going to participate in QRT.
There's also the matter of the pending OVI that we checked for results. It's a urine screen, and we don't have those back yet. However, we do have the results of the possession charge. The drugs were verified as meth, so we do have that.
Okay. And, wow, April the 12th.
A lot of urine pouring in there from different directions.
I guess. They need to hire a few more folks.
I would think so.
Okay, June 20th is the next hearing.
See you next week at 10 o'clock. 10 o'clock, yeah, for today. See you then. Keep up good work. Thanks, man.
State of Ohio versus Dagger and Devon Leonard, case number CRC 2553, TRC 25698,
June 20th.
A, B,
June 20th.
and CRA 25195.
This is Mr. Smith's case.
Your Honor, looks like there's a certificate as well, if I can approach.
Yes. Okay, are we ready to do the sentencing today? How do you want to proceed?
We wouldn't be opposed to that, Your Honor. I'm just,
There was a plea last time, I believe.
yeah, he pled to the theft and the OVI, and the possession was left pending for him to complete his treatment. So completed?
Your Honor, I don't have a problem with, he still, looks like he's still treating with RRS too, and he is on an ankle monitor right now, so if he were to be sentenced, we'd ask that the ankle monitor be removed so he can seek employment and he can continue with RRS.
We got 3 people waiting on today, at least, in the court. Okay, Mr. Leonard, anything you want to tell me before I sentence you?
No, sir.
Okay. Your reports are good. So let's start with the OVI. That's 25,619 A and B. That's the first offense. Okay, there was a refusal, but you're going to treatment. So what I'm going to do, usually on a refusal, I give people $1,000 fine, so I'm going to impose $1,000. But I'm going to suspend 500 of that 1,000 if you complete treatment. I'll order you to pay court costs. I'll order you to do 5 days of community service. I'm going to order you to do the DIP school, which is the driver intervention counseling program, but I'll not require you to do that if you complete treatment. So there's another, what is it now, $400 or $500 you can save yourself if you do complete your treatment. So we're up to close to $1,000 you can save yourself by doing treatment. License suspension will be 6 months, and that I'll start it the day of the offense, so it'll be good until September 27th, which is your license suspension. If you show proof of insurance and you get a job, I'll give you some driving privileges. No, I can't. I just saw, you have a charge of no driver's license, so I can't give you driving privileges if you don't have a driver's license, so take that part out. You have to get your driver's license before I can give you that driving privileges. So that was one of the charges. So that's the B case, no operator's license. I'll impose a $100 fine on that. Set his review hearing for July 25th. Since you're still in treatment, I want to monitor what you're doing in treatment. I will order his monitor removed.
I also have 3 monitors waiting to be transferred to Carl Wells' office. They just haven't been arranged yet. So as soon as that happens, our ankle monitors will open up.
Okay, so we're going to have some more.
Yes.
Okay, on the theft, that's 2543. Case number. Okay, on that, $100 fine, court costs. I'm going to do 30 days in jail, all suspended, on condition that you complete treatment. This is the hardest part of this sentence for you, where you stay out of all Walmarts. Not allowed to go in Walmarts anymore. 2 years probation, review hearing, what I said, 25th, I think, July 25th. July 25th is your review hearing. And then you have a felony possession that's going to let it pen. If you do complete your treatment and do well, it'll get dismissed. It's the most serious charge. It'll go away. So you got a bunch of incentive to do well in treatment. And if you do, you'll never see the dark side of the jail door. So, any questions, Mr. Winter?
No, sir.
Okay. Keep doing what you're doing. And talk to Mr. Major about getting that ankle monitor taken off.
Okay. And he'll give you the judgment entry with everything. His office is to your left, in the hallway, and your left, and go straight back, and you'll see us. Okay.
All right. That's it. Thank you, Your Honor.
You are.
State of Ohio versus Tony L. Scarberry.
Oh my goodness. You know, the worst possible production values But somehow one of the most entertaining courts I've watched in a while. Maybe it's just the day, maybe it's the fun that we had in the chat, but who says court can't be fun? That was hilarious. And I like how at the end he says the hardest part about this is going to be the Walmarts. And as somebody pointed out in the chats, it's like all they have there. So, oh man. That was entertaining. This was a weird day. The courts that I usually like to go to, none of them were doing anything overly exciting or things I really don't want to go to unless I have to, like landlord-tenant, because landlord-tenant's just often tough to watch. But it was hard technically, too, a little bit behind the scenes. I have two computers that pull this off, one that handles the stream and another one that handles the upwards of 15 courts that I'm watching at a time. And then I bring over links to the courts that I'm watching. I bring over 5 at a time to the streaming computer, and they're kind of my top 5 that I keep lined up for when we cut to other places. But my link between them was broken today, and I didn't discover it until we went live. So I've had to work things much differently than my normal workflow. So hopefully I was able to pull this off in a way that wasn't too clunky, but it was exceptionally difficult to do this today. So hopefully it came across okay. But this was fun. Hope you enjoyed it. We'll be back Monday. Yeah, Monday. Today's Friday the 13th. So back Monday, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. If you enjoy what we do here and you want to support the show, go to the pinned chat, become a channel member. It's incredibly inexpensive to do so. You get some fun extras, but the big thing is the pre-show where we have some fun. Today we actually covered facts around Friday the 13th and why it's a thing. So we learned some stuff in the pre-show today. But again, we'll be back on Monday. In the meantime, stay safe here on Friday the 13th. Have yourself a great weekend, and I look forward to seeing you all on Monday. Take care. God bless.